in other departments as well. I'm not the only department here in the 8th Judicial District.
You may be.
Maybe here on Friday afternoon here. That,
yeah, but right now you might be.
But, no, I have.
Your Honor, let me answer it in a couple of parts.
Yeah, sure, no worries. Thank you so much.
Tricarci says the jurisdiction needs to be based, quote, on acts expressly aimed at Nevada.
Right,
And it focuses on this idea of expressly aimed. And I do think it's important to highlight that when we're talking about internet services, there is a different test than applies to physical products. And that's because internet services are available everywhere. And the Briskin case that we've cited and that the state cites in its papers at its motion page 9, the Briskin case says there must be, quote, some differentiation of the form state, some prioritization of the form state, something substantial that goes beyond the baseline connection that the defendant's internet presence already creates with every jurisdiction through its universally accessible platform. And that's the concept in relation to the internet era. And when we're talking about social media services, there does need to be some specific targeting, something very focused on the state. And otherwise, the concept that there could be nationwide activity that gives rise to jurisdiction everywhere, this is what the courts have said very clearly is inconsistent with due process. And so, yes, Your Honor, I would say that there needs to be activity that's targeted at the state, expressly targeted at the state. And that's, I take the Tricarci language, but also Briskin becomes an important additional explanation as to why that is important. Now, counsel talked about the Ford Motor Company case. But in the Ford Motor Company case, the Supreme Court made explicit that it was not addressing the question of jurisdiction in relation to internet services. And the court specifically acknowledged that those could present different doctrinal questions. And so what you have is a national or even international activity that is not differentiated in Nevada in any way. And our position is that that is not relevant to this question of personal jurisdiction because it is not aimed at Nevada in any meaningful way. It's this identical impact in every state in the country. Indeed, it would be the identical impact around the world in various respects.
So who would be able, where would that case be able to be filed? I don't want to give the various examples that are coming to mind, right? Not saying your client does anything impermissible, right? Say there's a hypothetical aspect that somebody's contending that something's impermissible. I guess I could say pornography is usually the easiest example that everyone throws out on things, right? Because that comes up a lot. And I don't mean the criminal aspect of it, I mean the civil aspect of it, right? So who are you saying to address, right? What Mr. Gayan said, that he's basically saying that nobody can, right, other than as possibly your state of incorporation, but is that the only state that could do it if there was activity that does impact residents in Nevada, that Nevada wouldn't have any ability to address if it thought there was a harm to its citizens?
Two answers there, Your Honor. First, there could be other conduct that does reflect the sort of express aiming or express targeting that could give rise to jurisdiction in a given state. It's simply not the case that nationwide activity that's undifferentiated, that is the same in every state. And I think it is very clear, issues like bump notifications or expanding the user base, these are undifferentiated. They're location neutral. They have no link to any given location. Those are the classic ones that could not be used to demonstrate purposeful availment. There could be other kinds of activities in a given state. And there have been examples of that particular research programs focused on teen mental health, perhaps in a given state, and then you're being sued on a teen mental health issue.
So
Maybe
who can sue on the location neutral activities of your client based on what you're saying? If they equally touch around the world, what I'm hearing you say is nobody in the world can address it, so.
well, they certainly can sue. I mean, and I
Who would have
want
the let me be more precise, since you're talking personal jurisdiction, who would have the personal jurisdiction to have the case be brought in that particular location if it's one of what you're contending is a location neutral decision?
well, you would need two pieces. You would need purposeful availment of the forum, which would obviously be true in California, as an example. You would also need to have the lawsuit arising out of those purposeful contacts with the state, and that's Tripartite makes those points clear.
But aren't you saying in a location, and this is where I'm trying to flesh out what you're articulating, because if you're are you articulating that location neutral decisions in a digital concept that you're distinguishing from a physical concept? Because obviously there's, as have the whole sales tax cases with regards to Amazon and things like that, and there's a whole thing about people can, right? A bunch of things that don't apply there, and if it doesn't apply to, if it's distinguishing it from things like opioids or cigarettes, right, or things that actually have some kind of, I'm going to say physical presence for lack of a better word right now. So if you're saying, are you saying digital providers who have location neutral decisions cannot be sued because there'd be no personal jurisdiction anywhere other than in California? Because the reason why I'm asking that question is, well, it's raised in their brief that they have a different viewpoint, right? And like an oral argument, but from just a practical standpoint, California's a wonderful state, it's our neighbor state, but they may or may not care about what's happening in Nevada, right? Or Utah, or Arizona, or other states, right? There's kind of the states' rights issue, there's kind of federalism, right? So I'm trying to get the understanding of where you're saying the company who engages in digitally location neutral decisions, there would be personal jurisdiction to sue them other than their specific place of incorporation.
The point, the narrower point I'm making right now, Your Honor, is that the location neutral digital activity is not an indicia that can establish personal jurisdiction.
But that's step two, isn't it? Isn't that your motion to dismiss and for the court to evaluate whether that is? I'm back a step, right, on whether or not it is something to, if the state got to decide everything that was within jurisdiction, right, you all wouldn't be in front of me. If you all got to decide everything, you wouldn't be in front of me, right? You're here in front of the court to ask the court to decide, should the court grant a motion to compel or protective order on the flip side with regards to requests that have been made, right? So the court has to evaluate, does it meet the Nevada standards for the information that should be produced consistent with jurisdictional discovery in a pending case in a Nevada state court as opposed to other courts in Nevada.
Right. Now, Your Honor, I want to go back to, so I'm not being unclear with the court on this.
Sure.
My point is that this sort of location neutral activity, a nationwide activity that touches every state identically, cannot establish purposeful availment in Nevada. There may be other kinds of activity the state can point to, but this generalized activity that is identical in every state in the country can't be a basis to show purposeful availment under prevailing case law. And as a consequence, it's not relevant to jurisdictional discovery either. And that's been a core point we've taken as to each of these requests that ask about activity that is not differentiated between Nevada and any other state in the country. I'm not purporting to suggest that there's only one place in the country Meta can be sued. It depends on the nature of the lawsuit. It depends on the nature of the purposeful availment in given jurisdictions. there could well be circumstances where there would be indicia of purposeful availment in a given state, especially in relation to a particular lawsuit. But here what we're talking about in terms of jurisdictional discovery is whether these location-neutral activities are subject to jurisdiction, and I submit that it's not relevant, and it's been really the core sticking point in terms of the scope of jurisdictional discovery.
But how is one determining that it is a, quote, location neutral aspect? Isn't it kind of, you all are getting to decide and you just tell the state, leave us? I mean, I'm not saying it's true or untrue, I have no idea at this juncture, right? But shouldn't they be entitled to see some of the information, to see if it does have plans focusing maybe on people for different time zones that you're going for the Pacific time zone, right, versus an East Coast time zone, or the various other aspects that apply to Nevada individuals, you know, a 24-hour state versus some other states that may not have such a 24-hour environment, you know what I mean, the late night things. I'm picking things that aren't specifically in here for an intentional reason, just to kind of treat it in a hypothetical sense. So how would this court deny a request for jurisdictional discovery just on the fact that one side saying these are decisions that are location neutral, and so therefore they can't possibly, because you can appreciate, I do get that, maybe not those same words, but I get that concept a lot. This can't go to jurisdictional discovery because of, guess what, I mean, whatever the X is that I've heard of in various other cases. And so this is not an unusual question for this court to ask, because I appreciate that your position, you've got some basis for that position, but I didn't see it in the discovery responses, the basis for said position. I didn't see anything on the meet and confers or in the pleadings that kind of explain that.
Well, Your Honor, I would say two things. I mean, often in discovery, this is the way parties negotiate it out. If the understanding is this a location neutral issue that has no specific focus on Nevada as compared to any other state in the country, and it's often negotiated out in good faith. But frankly, even with guidance from the court, if the guidance from the court is location neutral information that is not differentiated between Nevada and any other state, if we had that guidance, that would really,
I'm sure you know that no order from this court is going to phrase it that way, because by definition, that doesn't, well, let's just say, there's no order from this court that's going to phrase it that way. I'm trying to utilize your phrasing of location neutral, right? Please go ahead.
Yes.
Didn't mean to sidetrack it on one kind of specific area. Go ahead, please.
But I think this is, so there really are these two core points. One is discovery beyond messenger, and the other is discovery on nationwide activities that are not differentiated as to Nevada. And those are the two areas where the parties are in very fundamental disagreement, and where we submit it's not reasonable and not appropriate for jurisdictional discovery to extend beyond messenger, because messenger is the only service at issue in the complaint. And it's not reasonable in jurisdictional discovery to be producing information about national activity, because it's not going to be relevant to purposeful availment under Tricarci and a lot of other case law. So those are really the two core points that I think are fundamental in terms of resolving these discovery issues, Your Honor. And we submit that the discovery we've already provided to the state is enough, because we provided the information to them on matters specifically related to Nevada. The lobbying activity, the user base, the advertising activity, that's been provided. So the pieces that haven't been provided are non-messenger activities and nationwide activities that touch this state no differently from any other. So that's where I would stop unless the court has more questions on that.
I want you to finish whatever your position was, please.
I also wanted to speak, Your Honor, on this point that counsel raised about the need to show the harms and effects on users and the need to be able to get discovery on all of Meta's national activities to demonstrate harms and effects on users. And again, I would point the court back to the Tricarci decision where the court said that the jurisdictional inquiry, quote, looks to the defendant's contacts with the forum state itself, not the defendant's contacts with persons who reside there. And that's at page 650, 440 P3rd 650. And again, I think that the point is, the question is activities targeted at the state. That is the litmus test for determining the scope of discovery. And therefore, national activities that affect this state no differently from any other should not be the basis for jurisdictional discovery. Let me just go quickly, Your Honor, to the 30B6 notice, which is Exhibit D to our motion for protective order. There's really two pieces that we need to address in relation to the 30B6 notice. One is that the notice is not confined to Messenger. And by its terms, it's asking for information about all of Meta's services. It's asking for information about Facebook and Instagram in addition to Messenger. And it should be limited to Messenger because the complaint is limited to Messenger. And that
Corporate
is...
structure, I gotta ask you a corporate structure question, right?
Yes, Your Honor.
Because the caption says, State of Nevada Plaintiff versus Meta Platforms Inc., FKA Facebook Inc., right? That's caption. So Messenger is not a separate entity, at least, well, if I base it on the caption, Messenger is not a separate, distinct entity for purposes of the litigation. So is your issue that it should be a subcategory of the defendant?
Messenger is not a separate named defendant in the litigation, but the complaint is solely addressed to Messenger. The complaint does not address Facebook, and the court can see that throughout.
190 some odd pages of, some 90 paragraphs of allegations, yes.
Yes.
192, whatever that was. Okay. But the reason why I'm asking this question, right, is because discovery usually, right, you look at the caption, and usually the argument is the person's not in the well, right? It doesn't have to be third-party discovery, or does it have to be first-party discovery, you know. Subpoenas versus depot notices, right? Because if they're listed part of the case, we're not going into interveners and fourth party and all that kind of stuff. But here, the argument I'm hearing is even though the entity who's on one side of the V is the defendant, there should be a subcategory of limitation on discovery that's not a party base, but within a party. And I'm saying because the party gets to choose, right? Meta got to choose how big it wanted to be, or if it wanted to have a whole bunch of subs, right?
Yes, the limitation we're seeking, Your Honor, is not based on corporate forms. It's based on the subject matter of the complaint. The subject matter of the complaint is confined to Messenger. And all of the allegations are related to Messenger, and the court is aware that there is a separate complaint with a subject matter of Facebook and a separate complaint filed by the state with the subject matter of Instagram.
Well, because you all tell me those two, unless they've been transferred to this court that I don't yet know about. No, I've got TikTok and other ones, but I don't have that one.
So I can simply represent to the state, to the court, that the state has filed these 3 separate complaints. But this complaint, the subject matter of this complaint is only messenger. So we're not asking for this limitation based on corporate forms. We're asking for the limitation because the subject matter is only messenger. And the court asked previously how many witnesses would be required. And this has a big impact on the number of witnesses, because we believe there could be 1 witness if it's focused on messenger, but if it's not, it's going to require multiple witnesses, and it adds tremendous complexity. But the most critical point is, Your Honor, it goes beyond the scope of the complaint.
And during your meet and converse, was this not clarified as to what was being sought?
Well, I think we've not been able to agree on this fundamental question of whether the state is entitled to jurisdictional discovery on Facebook and Instagram. And the Facebook and Instagram subject matters are encompassed within the state's 30B6 notice.
Okay, so. Go ahead, please. I just was.
So Your Honor, that is one fundamental limitation that we seek from the court in relation to this 30B6 deposition, is to confine it to the subject matter of the complaint. And again, I go back to Tricarci, where it has to be the suit-related conduct that gives rise to personal jurisdiction. And the only suit-related conduct that can give rise to personal jurisdiction here is conduct involving messenger. So that is one limitation we seek, Your Honor. And there is one other, which is in relation to request 5 of the deposition notice, which seeks information on the distribution of software updates that enabled end-to-end encryption for Nevada users. And that has no link to the personal jurisdiction issues. It's solely a merits question. The court heard significant testimony on this question of end-to-end encryption and the distribution of updates to move to end-to-end encryption. It does not bear on this issue of personal jurisdiction. And again, it's a nationwide activity. The question of software updates that enable end-to-end encryption, it does not have any specific focus on Nevada.
But reading the plain language of the 30B6 designation, right, number 5, which is on page 20 of the exhibit, right? That one does say for Nevada consumers, right?
Yes.
So are you contending that would not lead to any potentiality of purposeful availment if actual software updates went to individuals residing in Nevada or quote defined as Nevada consumers for purposes of the complaint?
It fits within the same concept we were discussing before. These were nationwide updates. They had no specific targeting to Nevada at all. They're nationwide updates of software. And there's no specific tie or link to Nevada or any other state. They cut across every state. They're location neutral. And so again, it is a category of request that is entirely neutral as to location and has no link to Nevada more than any other state in the country. And therefore, in terms of jurisdictional discovery, it has no relevance. I understand it may be a merits question that the state wants to ask about. But at this stage, it's not a basis for jurisdictional discovery.
Okay. Can I give you a hypothetical? Okay. Say Meta wanted to charge $1 tax to everyone around the world to use Messenger, right? Gained income on it. $100 really doesn't matter because this is my example, right? So that would be location neutral, around the world decided to do something, okay? I use the word tax, I should have just said charge, right? $1 charge, $100 charge, whatever, premium, whatever you want to call it. Then, under, if it was monetary, are you still saying that location neutral decision, because I'm picking something that's not an item, because I understand you're making a distinction between items, right? To go away from cigarettes and opioids and things like that. So money can be exchanged electronically, okay? So a digital concept, so it's not the hard, whichever, another $1, $100, whatever you're doing. So whether it's Ben's or George's, right? It doesn't physically have to happen, it can happen electronically. You're contending that the state of Nevada would not have a right to say that it had personal jurisdiction to try and litigate such a case, and caution, there is a case kind of that maybe one of you might want to ask your local council about called IGT, that I'm paralleling this off of.
Look,
See, that's the challenge I'm having. And if you need a second, 122 Nevada 132.
Well, I think there's two separate questions, Your Honor. One is that purposeful availment within the jurisdiction? And depending on the way the facts unfold there, perhaps it may be or it might not be purposeful availment in the sense that there would have to be some transactional activity between individual consumers, perhaps, perhaps. And perhaps some way to enforce whether the consumers actually paid. So in that sense, I think it presents a different issue on purposeful availment from this. But then secondly, the suit, the second prong of triparty and the second prong for personal jurisdiction is the lawsuit also has to arise out of the contacts with the state. So it would also depend on what the nature of the lawsuit was. It's not simply whether there's contacts with the state, it's whether the suit arises out of those contacts. And so it would depend on the nature of the claim being asserted.
That was a key tam action, okay, and it was whether or not private plaintiffs and stuff, but it goes to that same concept because it was going with regards to assertions on the payment of taxes. And whether or not you might say it falls outside of the state of Nevada, it was purposely only in the state of Nevada, might be a little bit of a different issue. I was trying to get to an example that I'm hearing what you're saying, but it's challenging for this court to say that a company can decide to just say, we do it nationwide or we do something globally, even if it has a direct impact. I'm not saying it does or doesn't, because that's the decision, right? That's the next step in decision. But somehow an entity couldn't find out if any said decisions exist, and that the entity that has the information gets to make that decision, just say, well, this is one of our location neutral decisions. And that you can appreciate as a challenge because it puts the control of the information into one party's decision-making power with an ultimate zero versus providing some information to allow the other side to provide to this court for analysis whether there is or is not personal jurisdiction.
Well, Your Honor, on some of these points that we're talking about in relation to the discovery issue here, I don't think there's a meaningful dispute that, for instance, efforts to expand Messenger's user base, those are nationwide activities. Indeed, the state takes that on, and I know what the state's argument is. Nevada is one of the states of the country. Therefore, if you're trying to expand your user base across the country, you're doing something in Nevada. Understood. My point is that's not purposeful availment. It doesn't make their case for personal jurisdiction. It could be relevant on the merits, I put that to another day. But in terms of whether it's purposeful availment, it doesn't work. Under Tricarci and a lot of other case law, it doesn't establish purposeful availment. So that's the point at this stage. I don't think we're really disagreeing.
Well, I'm not making a position one way or the other,
Why
I'm
not?
asking questions.
But I meant this, the state and Meta are not disagreeing that some of these activities the state is talking about are nationwide. I don't think there's a dispute about that. I think it could be a different question if the state said, well, Meta says this is nationwide, but we think it's only in Nevada or only in certain, what the court used the phrase 24-hour states. There might, but I don't think that's the issue here. The issue here is a national activity that has no differentiation.
They're saying
By
it doesn't
state.
define purposeful availment because it dips its toes everywhere, it doesn't.
Right,
jump in.
it doesn't suffice to establish purposeful availment. Your Honor, before I sit down, I'd like to point the court back to something we discussed at the start of my presentation on the production we have made to the state. And if the court has available the state's opposition to the motion for protective order, Exhibit 3.
Go ahead, please.
And the court can see there, these are the counts of users that we estimate are in Nevada, over 18 and under 18 by quarter. And so this is the information that I was describing that has been provided to the state. And the bump notification example that we were discussing would be subsumed within these counts inherently. And so insofar
Because
as
this is dated as a particular date?
this is dated as particular quarters.
Okay,
So insofar as the point is there's notifications going to users in the state, it's going to be that the more, if the state thinks that is relevant to jurisdiction, we don't think it is, but insofar as the state thinks that's relevant, they have the counts of users. And so my point is they've gotten the information on the theory that they believe establishes personal jurisdiction. They've taken the position they have enough to establish personal jurisdiction. Based on the material we've provided already, that's why we believe that there's no more jurisdictional discovery that's needed at this stage.
okay, I appreciate it. I do have one last question, and this kind of goes to your question about discrete and shortened time period. In order to have filed a motion to dismiss on personal jurisdiction, right? Under Rule 11, you have to have good faith belief it exists. So part of realistically the court's analysis on why this would be rather short is because presume that you all would have done a detailed analysis of what you were taking into account in order to file said motion to dismiss, right? Taking a look at Nevada.
Yes, Your
And
Honor.
seeing what was or was not done, rather than just quote filing a motion to dismiss. So is it your contention that the charts that were provided in response to discovery are the only charts that would have a column region Nevada in it? Because I'm going once again, yes, I am segueing back to your saying location neutral, the fact that, so.
This information that the court's looking at now, the chart that I pointed you to, is a data pull that was done from a database. But in relation to the court's question about our basis for asserting the
And
lack
I'm
of...
not talking about your attorney-client communication.
No, I understand.
I'm just talking about, I presume there was data pulled and information pulled because in order to make that good faith determination before you file such a motion, something would have need to have been done.
Yes, Your Honor, and there's really 2 points. One is there purposeful availment in Nevada as compared to any other state? And in our view, there's not. And I think it's demonstrated by, for instance, the lack of any targeting of Nevada in any of the messenger programs. There is no targeting of Nevada. There are activities that are nationwide that touch Nevada like every other state, but there is no targeting of Nevada, so there's no purposeful availment. And second, the allegations of the complaint, which are based, as the court knows, on issues such as end-to-end encryption and or alleged impact on youth health, those claims do not arise out of any of Meta's contacts with Nevada. And
how about all those cookies people can opt in and out of, right? I'm not talking chocolate chip or oatmeal raisin. I'm talking about, right, the digital cookies, right, the strictly necessary, the analytics, right, the targeting and all of those. There's none that are Nevada-based that haven't been produced. Is that, because I saw there, you know, from the Messenger app, I'm not focusing on the other aspects of it, even just on Messenger. You're saying there's none of that, those are all location neutral?
Your Honor, when you're asking, for instance, about cookies that would go to users or
Yes.
so that would be cookies in relation to third-party advertising, as I understand the court's question.
Well, not necessarily, right? Even to go on to the Messenger app, don't you? Now, I will tell you, I intentionally do not, because I've got this case before me, but most anything you sign up for these days, there's really not a website that you can open or an app that you can open that doesn't say that there are cookies, right? This site uses cookies, and then you have to go in and decide if you're going to accept all, or you're going to make your own choices, right? The strictly necessary cookies, the analytic cookies, the targeting cookies, and there's some other cookies I don't. Those are the ones that come to this court's mind. So when I was reading the responses, cookies did come to my mind right away, just saying, are those not Nevada-based at all? So you just get global information from around the world?
I would go back, Your Honor, to the proposition that these are nationwide, location neutral.
Cookies? They don't target? They don't give you location?
Cookies, I mean, a user may click on the cookie preferences, but that's the user's choice. It's not the choice of the defendant here, Meta, and it's very clear under the case law that the question is not what third parties choose to do or engage with the service. And that's the point, and the Briskin case, I think, is really critical here because it talks about the baseline connection that an internet service already creates with every jurisdiction. And so
but isn't the decision to put the cookies, I'm back a step, right? Each entity decides whether or not they want to potentially have cookies, right? The fact that you now have to disclose cookies is regulation-based, but, right? Not every site, let me say, that's why I use the term almost every site. I don't go on that many of them, but okay. Usually you see people want targeted cookies, right? I mean, how can you do a bump without a target, without a cookie? I mean, how would you know?
The bump notifications would be going to users who have not used the service for some period of time, Your Honor. But again,
and how would you know those users are not using the service unless you're doing some method of tracking those users and their actual usage of the service?
But it would be tied to usage of the service, not tied to this jurisdiction. It's not purposeful availment of this jurisdiction.
Okay.
That I think is the distinction, Your Honor, between this sort of nationwide activity that has no location focus versus other activities that could involve purposeful availment of a given jurisdiction. And at this point, without straying into the merits too much, Your Honor, the point is...
Yeah, I'm not trying to go to merits, but that's, I'm realistically focusing on the jurisdictional discovery. If you have a right to the jurisdictional discovery, it would be the type of information that goes to jurisdictional discovery, which goes to the type of information that has the valid components in order to do the appropriate analysis under the applicable case law. In order to do the appropriate analysis under the applicable case law, I need to have a clarification with regards to where certain things are being contended from each side. I do appreciate it. Thanks so much. Sorry I asked a lot of questions, but trying to make sure it was all clear. Appreciate it. Thanks very much. Okay, counsel for the state. You semi get last word because I'm likely to be asked to get last word. So go ahead, please.
All right. Thank you, Your Honor. And Michael Gayan for the state. Okay, there was quite a bit there to address. Your Honor, I think where I want to start is with counsel's misstatement of the law. We repeatedly heard counsel say that the analysis is whether the state's causes of action and allegations arise out of Meta's forum-related contacts, okay? That was clearly explained by the Ford Motor Court in 2021. And it's not surprising that Meta wants to focus on tricarchie. And particularly, I found the part that counsel quoted from tricarchie, and lo and behold, it cites Walden, the Supreme Court Walden case from 2014, which was discussed by the Ford Motor Court. And Your Honor may recall Walden, but in the Ford case, the Ford court says right near the end of the opinion, but Walden has precious little to do with the cases before us. In Walden, only the plaintiffs had any contacts with the state of Nevada. This was Nevada residents who were traveling, and something happened in an Atlanta airport, I think it was, and it sounds like, it looks like maybe the court is familiar with the facts of Walden generally, but in Walden, the plaintiffs tried to sue a Georgia resident who worked in the airport for injuries that occurred in Georgia here in Nevada simply because they lived here. And the Walden court said, that's not good enough. And in Ford, they say the officer had never traveled to, conducted activities within, contacted anyone in, or sent anything or anyone to Nevada. The Walden facts have nothing, like Ford, have nothing to do with the case before, Your Honor. Meta has gone to great lengths to gain users in the state of Nevada. So I want to make that crystal clear that the Ford court explained rejected Ford's argument, like Meta, that there has to be a strict causal connection between the forum contacts and the causes of action. That has been rejected by the Ford court in 2021. That's 2 years after tricarchie. And the state's position would be, to the extent tricarchie can be read to require a strict causal connection, it has been rejected, and it is now bad law under the Ford Motor Company decision, because tricarchie and all Nevada decisions rely on the Supreme Court of the United States, because our state's long-arm statute is coextensive with the reach as explained by the U.S. Supreme Court. So that I wanted to explain briefly. Another thing on this point is we heard Meta's argument, this is in their papers as well, extensively, and we addressed these in our briefings. But virtually all of Meta's cases on internet presence relates to static websites. Meta is not a static website, and it is, and from the documents cited in the state's complaint and in our briefing, Meta is not operating a static website hoping people show up and use it. That is not what they are doing. There is substantial activity, and that activity to grow users and track users is on a state level. It is down to the state level. And I would urge the court, and for the ceiling-related discussions that we talked about earlier, I will not quote it, but I would direct the court to RFP 30, where information is quoted from an internal Meta document that shows Meta tracks certain information on a state level. So to say, compare Meta to a static website is just a completely false comparison. Obviously, I understand why Meta would like to do that. Those cases are so wonderful for a defendant trying to get dismissed for lack of personal jurisdiction. but unfortunately, they have nothing to do with Meta or its business model, or its contacts with Nevada or its activities. Another point I'd like to make before I get into other things is, and I tried to articulate this in my earlier comments, but Meta's arguments essentially are that because its activities, and this goes to the court's questions about content neutral, and these arguments that Meta is making about content neutral decisions and activities.
Location neutral.
Location neutral. But Meta is effectively arguing that because its conduct is expressly aimed at everyone, then they've not expressly aimed it at anyone. So because they put it out to everyone, then it's not directed at Nevada specifically. Well, that is just factually wrong. Meta clearly wants all of its decisions and conduct and business to impact Nevada, to come into Nevada. It has millions of users in the state, and it wants those decisions to affect Nevada's users and consumers who haven't yet signed up. They're trying to get more users, of course. And this kind of ties in with another way I'll describe this, Your Honors, the location neutral. Another way to describe location neutral, based on how Meta operates, is omnipresent. It's everywhere. They are everywhere on the whole planet, and they're trying to get more reach all the time, including in Nevada. And decisions they are making are designed to reach into Nevada and get more users and get users that they already have to use their platforms more. Because the more people get on the platforms, the more data Meta can collect about them, and the more valuable that data becomes to sell to advertisers and get more specific and granular information to sell to advertisers so they can do targeted advertising. This was in our papers, but that is Meta's entire business model. We cited their public SEC filings. Their entire business model is they're an ad company. That's it. And they found a fancy way, shiny object that everybody wants to use so that they can gather this information. And that is what consumers in Nevada give. That is the consideration that Nevada consumers give in exchange for the ability to use Meta's platforms, including Messenger. The state has an entire section on this in its complaint, and I wrote it down, and now I seem to have lost it. Maybe Mr. Slade has that for me, but starts at paragraph 39. Thank you, counsel. Paragraph 39, I think it goes through 50-something. There's a whole section about how Nevada consumers exchange valuable information, personal information, location information, etc., in exchange for the right to use Meta's product. And it kind of ties in with the court's cookie question. This is in Meta's user agreements. This goes way beyond cookies. There's geolocation information. They place things called pixels on your devices, beacons. And I don't want to get too technical because I couldn't even explain it all, but it's way beyond cookies. They are disclosing to people that they are going to track all of this information and use it to give you a more personalized experience. And that means localized content, localized ads, things that you seem to like. And they are using your location to feed you more specific information and more specific ads, and that's why they can get more money than from advertisers than just putting it in the newspaper, for example, because they can reach a specific demographic in a specific location. I believe their user agreement, and I'm going from memory here for my preparations, but they said if you wanted to reach a woman in Madrid who's from 25 to 35 and interested in such and such, we can help you with that. So that is the type of information that Meta gathers from its users, and why it is doing all of the things that we have alleged, the state has alleged in the complaint. That's why they have these addictive design elements. That's why they send bump notifications. That's why they do all of it, is to get people on so they can collect your information, so they have more current information on where you are, who you are, what you like, so they can sell more ads at a greater price, okay? That is the entire business
So
model.
the question, counsel for Meta set forth that you already have the bump information in the confidential document Exhibit 3, which gives you the numbers. Are you going to go there?
That was actually my very next point, and so, beautiful segue, Your Honor. And this is under an umbrella of Meta's argument that, oh, well, Meta has provided so much information. Well, you know, if I were in their position, I'd be arguing the same thing, and I'd have a nice chart like they had, or a list of bullets of all the wonderful information they've provided. Well,
Compliments to both sides of the proceedings, they were very nice.
very good briefing, you know, it was very clever. That's what I would have done if I were in their position and not wanting to give up any information and get to the motion to dismiss
The court's
hearing.
not saying that, the court's just saying you all did a nice job on briefing on both sides, which is why the court has so many questions, but go ahead.
I understand, I wasn't trying to twist your words, I'm still advocating and I
No
can
worries,
turn it
go
off.
ahead.
Okay,
I
so,
think you're gonna tell me your email was advocating, but go ahead.
so users and bumps are not remotely the same thing. And I'm shocked to even hear that. We heard from counsel a little bit later that I heard him acknowledge that bumps only go to users who are inactive for a certain period of time. Well, that's the point. Someone somewhere is deciding what, and I've said this before, someone somewhere at Meta is deciding what the criteria is on how long you have not opened up the Messenger app or Facebook or Instagram, and you need a bump because we need to get you back on our platform. Someone's deciding that, and we don't know, and this goes to the court's questions, or at least my view of the court's questions. We can't take Meta's word for it on all of these things. That is the point of discovery. I mean, counsel represented a lot of interesting things. We would like to get this information directly from counsel's client, from Meta, and ask someone under oath and get interrogatory responses and RFP responses that are subject to the penalties under Rule 26G and whatever else, and verifications and all of those things. That's why we go through the discovery process, so the opposing party can satisfy itself on the facts. And I'm sure Your Honor has seen this many times, probably just in the last 2 days with my partner's trial in front of you. Parties sometimes disagree as to what a document means or what it involved, and that's a fact question for the court to resolve as well, or the jury, depending on the case. But in any event, Your Honor, bumps and users are not remotely the same thing. I think, you know, tying back into the Ford Motor Company discussion that we had, I think it's pretty obvious why Meta does not want to give up bump information, because it shows purposeful availment directly right into its users in Nevada, that it is trying to get them to use the product more. And by the way, as a reminder, bump notifications is one of the design elements that the state is alleging is creating addiction among Nevada children. So there is a little bit of merits overlap there, but clearly it goes to purposeful availment. Another thing I wanted to point out, Your Honor, is we heard about Briskin just before I left the test. We did hear about the Briskin case. I would point the court to, and I believe this was brought up on reply, so we haven't had a chance to address it. And I don't want to spend too much time on it, but it's on 87 F4th 412. And it actually ends on 412. But the Briskin court is actually discussing the purposeful availment and the effects test under Calder. And it says, the court there says, we construe intent in the context of the intentional act test as referring to an intent to perform an actual physical act in the real world. That's a pretty broad definition of an intentional act. Then the Briskin court goes on to say, acts undertaken using technology can qualify as intentional acts, period. And it cites two other Ninth Circuit cases, Verbal Brands from 2023 and Wilco from 2022. So Meta's argument that operating in the metaphysical world is somehow a different test is just not true. That's not supported by the law. There's not some magical separate jurisdictional test for internet-based companies. Completely disagree with that. As far as the location, I heard counsel mention Exhibit H. It was talking about the location, like that Meta had given robust information about its location services and operations, and I looked it up, and that RFP response 14, it's their protective order motion, Exhibit H at appendix page 52, RFP 14.
Can you repeat what you just said, please?
Sure, it's Meta's motion for protective order. I don't have the document number, but it's.
No, right, I've got it, I got it.
It's
It's
exhibit-
a courtesy copy, so it's okay.
Yeah,
So
so
it's
it's
the appendix attached there too.
52, page 52 of the separately numbered exhibits, which turns out to be Exhibit H. And it is Meta's supplemental responses to the RFPs dated April 19th.
Let me ask you a different clarification question. Let me let you finish, then you have a question on this.
Sure. So I just looked at that, and that RFP response cites 2 pages of documents, and that's it. So I don't know what else, if counsel was referring to something else, but on a request seeking documents sufficient to show how Meta collects or has collected, uses or has used, relies or has relied on location targeting data collected from Nevada consumers from 2015 to the present, 2 pages seems insufficient on its face.
Globally, with regards to supplemental response, can you refresh the court's recollection? It was unclear in the pleadings. Were those supplemental responses voluntarily done, or were they done so that they only needed to supplement after a meet and confer? For example, you referenced previously RFP 30. RFP 30 was not one that was supplemented. So was that by agreement of the parties, or was there a self-determination about which ones would be supplemented?
That's a good question, Your Honor.
It was unclear, so.
Yeah, I think supplementing April 19th, I don't know for certain, but just my recollection of the letters that went back and forth, I believe they're attached to our motion to compel, the whole packet of letters. Excuse me. April 19th was likely a supplement based on some meet and confer discussions. And I know there were some later supplements, for example, to an interrogatory response, maybe at the same time or shortly after we filed our reply on our motion to compel. They did provide a verification. I know that I saw that in our reply, but maybe concurrently with our reply being filed or shortly thereafter, Meta did get us verification pages. So
was there a waiver or determination that, look, for certain meet and confers, oftentimes it happens, you've got X number of, right, RFPs, ROGs, whatever you have. Request for admission really doesn't matter. And you say, guess what, we only really need numbers, blank, blank, and blank. Can you supplement those, right? And we'll be okay if you don't supplement the other ones. Using phrase maybe a little bit differently. Is that the situation here, or was that a determination by one side about what they wanted to supplement without waiving or without an agreement that if they supplemented certain ones, that therefore it was not required to supplement others? And I'm going to ask both sides that question.
Yeah, Your Honor, I appreciate that. My recollection is there was some discussion of horse trading, things like this or that. And that may have been discussed in the meet and confer, but based on Meta's positions in the letters as far as the scope and dates and platforms and all these other things that are before the court now, that the state never withdrew anything at all. So the state is asking for responses within the scope of what we've laid out in our papers. I believe we have agreed to go to 2017 based on our papers, and we're not moving all the way to 2015 at this point. But beyond that, we have not, the state has not withdrawn or waived anything to the best of my recollection, Your Honor.
You understand why the court's asking, what's the scope of what each one is? It's some, because, and appreciate the nature of litigation, as experienced counsels, we sometimes have rolling things that come along, so trying to be clear, because conceptually you have certain things, right? The topic areas, but those topic areas go over a variety of distinct RFPs and ROGs, and then we're going to be 6 separate and apart from that. So what would you, I'm going to the potential order, and I mean, you see that you're asking this court, because usually on discovery, right, it's they need to supplement RFP blank, 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 or blank, or they don't need to supplement RFP blank, 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 or blank. But you all have done it in a more global context, and I appreciate why, but it's, I'm thinking of the court's ruling, I need to be specific on which ones are or are not, because it may raise different things unless, right, I not solve your issue clearly what is needing to be done if you're not referencing it by specific discovery requests. So hence, what's your final answer on which ones are actually before the courts?
Well, as Your Honor saw, I needed to phone a friend during your question,
No
but
worries.
I would say
You can reach out to the rest of your friends, and others I can reach out to their friends too. It's
there's
audience participation, if you want, go ahead.
there's no 3 lifeline limit in Department 30.
I'm just trying to get it, so get you what you need in accordance with applicable law. And my team is politely reminding me that I need to take an afternoon break, so I'm not sure, maybe now might be a good time, you all want to consult with each other.
I
And
think
before
that
you've
might make
gone,
sense.
maybe you come to a final way that you want the court to look at things. Would this be a nice time for a break, for people to talk?
Yes,
Last
Your
time
Honor.
we gave you a break, you were very productive, except you're not getting 2 hours this time.
We'll be quick. We have about 15 minutes.
15 minutes, so why don't you come back at, you want to come back at 5 minutes before, because it's kind of in between the two?
Perfect, Your Honor.
3:55, thank you so much,
Thank you, Your
appreciate it. Okay. Back on the record, same case, same parties, still on 886-110, counsel for the state. Before the break, you want to finish up some statements? Go ahead, please.
Sure. Before I continue, I just want to address the court's question. We did have a chance to meet and confer, the parties did, and reached agreement that it would be better for the court to address its rulings topically rather than on a per request basis. And if that, for a number of reasons, that's how the parties briefed it to the court, so it'd be difficult for the court to then go through it. It's a lot of extra work.
That's my question.
A lot of work for Your Honor or your clerk, or that is unnecessary. And you know, we've had a very good professional working relationship with the opposing counsel, and we trust that whatever ruling Your Honor makes on a topical basis, the parties can meet and confer and reach agreement on the scope on a per request basis. And if we can't, we will obviously come back to Your Honor, but our discussion was that no one is remotely interested in doing that. So we're motivated to work together and apply a topical based ruling across the whole set of discovery, including deposition topics. So that would be, you know, the platform dispute, the youngest user dispute, the time limitation, et cetera. The only ones that may require specific rulings would be the ones that the state called out specifically, RFP 11,
13 and 30.
and then ROG 13. And then there was a whole section of requests for production 20 and 36, I think, that was discussed in a block on pages 15 and 16 of our motion. We go through those, but I think after we talked about it, we specifically discussed that on the break, that if Your Honor makes the topical rulings that we can apply it to those. And the primary issue in that block of requests for production related to Nevada-specific versus nationwide. So if it's, Nevada's in the United States, so if they're talking about growing users in the United States, it's inclusive of that dispute. And I know Your Honor is aware of that, but I think that's how we would, the topical ruling, additional topical ruling that would help resolve the issues in that section. And in particular, just recalling Meta's motion for protective order, the way they described their objections to that section was something like site-specific or something, because they related to specific Meta documents, and they're saying, well, that document wasn't specific to Nevada, and so it shouldn't be part of discovery. So I think that's it. Hopefully that answers the court's question. And
presents a challenge, okay, but let's be clear on what they're doing. Okay, so walk through the agreed upon topics, because you all have phrased them different linguistically. Conceptually, they're very similar. Let's go through your topics and then what the ones you're saying are specific.
Sure. I think the way I would characterize them, and I'm willing to have Mr. Hester comment after I'm done right now, just so we can hopefully reach a consensus on this, instead of waiting until his final comments. But I would characterize it as platform, whether it's Messenger specific or Meta's other platforms, Facebook, Instagram, et cetera, to the extent they involve Messenger or implicate Messenger in the state's discovery requests. The youngest user dispute, U13. The time limitations, 2017 or something less than that. I can't even recall what Meta was advocating.
You were 2021,
21 or something like that. Yeah.
Well, then we move back to 2019, Your Honor, is the compromise.
Okay. So that's the dispute there. Then there's the RFP 11 one on marketing and advertising. There's the Meta's refusal to answer RFPs 20 to 36, and I believe I would characterize that as the nationwide versus Nevada specific dispute. Interrogatory 13, that's the bump notifications. And then Meta raised a couple of other.
So you're no longer 30?
30 was an example of
20 to 36?
20 to 36 to show that Meta tracks certain information on a state-by-state basis. The other categories that I pulled from Meta's briefing was they had some objections on time spent metrics or requests, and that's a topic. I think we've kind of covered that, but I just covered that before the break, that time spent by users is important because Meta can gather more and more information and leverage it for its money-making purposes. So time spent is an important bit of information. And then Meta also had, and that, just for Your Honor, since I see Your Honor taking notes, that was in, the state addressed that in its protective order opposition, pages 9 to 11, that's the time spent argument. And then also, there's also internal discussions that Meta's objecting to, and we addressed that in a separate section on pages 11 to 12 of the state's opposition to Meta's motion for protective order. So I think those are the categories, but I'm happy to have Mr. Hester comment.
Your Honor, I might generalize it a bit more. We had envisioned that these categories or requests that are not location specific, that are location neutral, should be excluded from the scope of discovery, and that's one where we could use the court's guidance. And I think that would cut across many of the categories that were just, specified. It's really a broader question of activity that is not specifically related to Nevada, but involves activity across the country. And as the court knows, that our position is that shouldn't be subject to jurisdictional discovery. So that's one. And then the other is this question on whether there should be discovery related to Meta's other services. And I just want to be clear on that because I heard a little bit of a different articulation, and I just want to make sure our position is that the discovery should be confined to Messenger and should not include the other services.
Okay. And Your Honor, just
You understand that the way you all are phrasing it presents a pretty big challenge in the world of the district court judge acting and overseeing discovery as part of the business court package, right? Because as you are familiar with the Venetian case particularly, right, is there has to be some analysis, right? And there's the concept of even if you object to parts, that you still need to provide parts. But realistically, what you're asking is, it sounds like some advisory, is getting to the gist of realistically, I wasn't going to use that word, but I might as well use it, is you're not asking the court to go the way it generally is done, right? Which is RFP by RFP, which is why I was asking my more kind of closure questions on the supplements of what actually is before the court. Because, for example, let's go back to interrogatory 13, right? On the sides it says has Nevada. I'll read it. You know, I mean, it's your bump one, right? That says Nevada consumers. So, is a court ruling on a quote topic basis really answer that one? Because that one, I will tell you, would be one specifically the court would have had concerns about because of the fact that it's an absolute not producing without raising any privilege to preclude a zero, I say the word producing, it's derogatory, so it's, you know, it means producing information, is obviously what the court's saying. And also, at the end of the response, it says, matter further objections derogatory to the extent it seeks data or information that may not exist in the normal course of business. Well, that's not an objection, and that's not even an answer whether it does or does not, and what the quote course of business would be. But then realistically, that kind of gets subsumed in the bottom line is based on these objections, Meta states will not provide information in response to this interrogatory. It doesn't give a basis on not providing any information relationship to that interrogatory, right? Which then goes to post-2019 changes to NRCP and goes to Venetian, et cetera, on the duty to still, and there's a whole bunch of presentations and advisory committee and things like that, that even if you got an objection to part, you still got to produce the rest, right? And when I'm using the term produce, I mean it both for interrogatories and productions in a different context, right? Information and interrogatory, some kind of response. So I'm hearing what you're saying, I'm seeing how that potentially can meet your needs, but it's an interesting challenge because these are phrased differently, and how are you not asking this court for an advisory opinion on, quote, topic areas versus the way that they are specifically articulated in specific discovery requests and your 30B6 topic. I understand it could help for a 30B6 depot. That one, you know what I mean? But since their questions are phrased differently and the objections are different in that some have referrals to, like there's some ROGS referrals to RFPs or some RFPs to other RFPs. I mean, unless you're both saying that nobody's going to raise any issue on the fact that you have specifically asked for, you know, topic versus documents, and no one's going to proceed any further with that, you understand that this court, asking this court to do something that really is realistically is anticipated and provided for with regards to a motion to compel or a motion for a protective order, right? It's supposed to be on specific information in response to certain things or a specific person, and so I'm trying to help you out, but unless you all are going to say, guess what, you're not going to raise any issues with the format of what you're asking this court to do down the road, I can't do it, because you're asking this court to do something that's not the way it's done with regards to discovery, and it's not providing any basis on really how I can do it unless you are specifically stipulating that you want the court to do it.
Well, Your Honor, I guess I would say, and I'd let my friend go ahead as well, but I would say we're not asking the court for an advisory opinion because there is a real live dispute on these particular points. And once we have the court's ruling on these points, then the parties can go ahead to implement it in relation to particular requests in a way that I think would be more efficient for the court and the parties than asking the court to rule one by one. I mean, these are clearly meaningfully disputed issues between the parties, so it's not advisory in that sense. It may apply differently to different requests. But
aren't you all going to take, just like you took how I used the term discrete one way, that you both interpreted it two different ways? I appreciate the benefit of your own clients, but therein lies part of the challenge, right? You want to use it, Meta would like to use the term location neutral. The state would like to use the term Nevada consumers, right? So that's not even, okay, so we've got a couple of different people. Are we doing one horse, one rider? Are we allowing more than one?
Yeah, if you'll allow me.
I'm happy to allow her on this type of a procedural.
I was just gonna offer, Your Honor, that I think the court's wanting to make sure that it's in compliance with the Venetian case. I would just suggest that the proportionality question is really what all these topics are addressing. What's proportional?
Part of their argument is that you all, I waived your objection on that because you're not giving a proportionality analysis. You said,
right, I was
you
just trying to
said the
say
magic word, but you haven't given an analysis. So really the first step of the court's ruling would have to be, did you actually raise the proper objection, or have you waived that by just using the word proportionality without explaining the burden and the benefit, right? That it would take X number of hours, would cost so much in order to do this type of analysis. And so therein lies.
I'm separating it from burden. I'm saying the topic itself. Our position obviously is the topic itself is not proportional. I think that's where we are. What's the proportional discovery allowed in a jurisdictional discovery setting, which is where we are on the merits discovery. And so we've agreed with the state, let's break this down by topics, because that seems to fit in this rubric where we are.
But you understand you all have you view these as two outstanding topics for Meta, and the state views it as 8 differently phrased ones.
Yeah, Your Honor, Michael Gayan for the state, a couple of thoughts. You know, the location, or excuse me, the topical approach seemed easier when we were discussing it out in the hallway. It does not appear to be the easiest. I hear the court's question and concerns.
So walk through if either side wants to raise an issue on this ruling, right? If both sides don't want to raise an issue and you're stipulating you're not going to raise an issue on the court's ruling, fine, I'll do it, right? Because I have a specific agreement by the parties, a stipulation under UDCR 7.5 on the record that you all wish the court to take a different process to give you guidance, and everyone's fine with that, so that's not an issue, and it could be in the best interest of the case. Okay, but if somebody's going to say that the court is not utilizing the proper process for a motion to compel a motion for protective order, then no, because you know what I mean? If you don't present it to the court in that format, then that would not be appropriate to try and, whatever cliche you want to use about round and square pegs and things like that.
Sure,
So,
Your Honor, I guess a few thoughts.
so you understand the court's formally doing it if you all come in agreement that there's not going to be an issue raised about the way that this is done and the court's ruling. But if you're going to, then we're going to do it straight by the book, ROG by ROG, RFP by RFP, and 30B6, 1 by 30B6, 1, because that allows the parties, if they're going to raise an issue. Now, whether you think that's the most efficient way to do it, like I said, I'm willing to do option A, but I can't do option A if someone's going to raise a challenge to option.
I think,
option A.
yeah, Your Honor, Michael Gayan for the state. I think the topical approach really only addresses relevance. Frankly, I don't know that it addresses any burden or proportionality issues, so I understand that potential issue and challenge if that's not handled. Now, obviously, I've argued today in
No, they're saying it's so overbroad, which some people view overbroad as being distinct from relevance because they're technically two objections. Some people view that they're the same because the overbreadth is with regards to relevance. We're not going to go up to that little path, but go ahead, please.
Sure. The state's position is that the burden and proportionality objections have been waived because they're boilerplate, and so there's really, we would want a ruling on that related to.
But you understand that's not in your list of 8 until I just mentioned that. And
Yeah.
I had to mention it because it's part of an analysis the court normally is going to do on an any type of discovery, issue, because you have to see if there is actually an objection preserved, because similar, you don't answer them, right? There's certain things that happen, depending on which one it is.
I think, Your Honor, on further reflection and comment from my co-counsel, I think it would be, for purposes of having a record on this, better to do it in the normal fashion.
And how can I do it based on the pleadings you all presented me?
Well, I believe the state has articulated it with respect to.
If you remember, it's supposed to be RFP by RFP, this is this, and then it's a supplement, and so this is the outstanding issue after meet and confer, this is the issue that's left out for the court. I'm not saying that you all don't have beautiful briefing, and I appreciate you both took a macro approach, which I can see from the needs of the case might be the way you want to go, which the court's going to be fine if you're both waiving any objections to the court doing that, because you can appreciate you're not going to do it, and then somebody says, well, guess what, it didn't address this, this, or this, or I, wanted more, because realistically, that would be not the best use of anyone's time or resources, and there wouldn't be a basis for me to doing it. So, like I said, I'm fine doing it if you both specifically agree on the record that that's what you want and you're asking the court to do. If you're not, then you can appreciate, I'm going to say, please follow the rules so that the court can provide you its normal, well-reasoned, that one side may or may not agree with, opinion, right, with regards to it, how it would normally be done. And I'm not trying to ask, I fully appreciate if we go that second option, that it may not meet your timing needs. And I appreciate that issue's out there, but you all have to decide which one you want to do. With all your years of experience, pick. If you're asking the court to do something special, then you need to specifically ask, and you need to say that there's not going to be an issue with it. If you're going to want to reserve in your back pocket, but guess what, we're going to raise an issue that it wasn't procedurally correct, then it's a advisory opinion, and it's not a ruling of the court, right? Because.
Your Honor, may I have just a moment? Based on that, I would appreciate just one short moment.
Sure.
For my client.
So you all are clear that the court's fine doing it if you both want it and you're both in agreement on the scope and terms. If either side wants to keeping their reservations and lawyering stuff, right, then that presents a challenge because you're really not asking for a court ruling, you're asking for maybe something that you might want to argue later, and that's not allowed, and that would not be at this time. You'll need another few months. We do have to stop at, you can appreciate, well, I don't know what you all's flights are, but that's your issue. I'm just saying, I'm more than glad to accommodate and get this done, but the separate and part issue, you can appreciate, we will need to stop at 4:45 so that my team is not incurring overtime. So I'm more than glad to need another 10 minutes.
Probably less than that. 5 minutes would be sufficient. And just to be clear for the record, the state is not looking to gain any procedural or advantage with this, and we'll find a way with Mr. Hester and his team.
And you understand, the court's more than fine accommodating you all. We just need to make sure that each party's full position is, okay, so that everybody's on the same page. So, okay, thank you so very much.
Thank you, Anna.
Thank you, sir. Go ahead, take break at 6110. Counsel for the state, I think you want to be heard. Go ahead, please.
Yes, Your Honor, Michael Gayan for the state. Unfortunately, the parties were not able to reach a consensus on how to approach this. The state proposed filing a short supplement with a chart similar to Meta's motion, pages 19 to 30, just to identify how the topics touch on each disputed discovery request, and then that devolved into Meta getting a response and other things, and the state's not interested in that approach. We're just trying to provide the court with the information it needs to rule on a request-by-request basis, including objections that Meta has asserted on each request. And we also discussed maybe doing the topical approach that the parties originally proposed to the court, but then I believe the court would need to rule on objections on a request-by-request basis, potentially, so that didn't seem to work either. So I think we're back to a request-by-request ruling, and if the court, and the state's happy to submit on the papers, if your honor says you don't have the information you need, then the state will supplement if ordered to do it, and will provide whatever information your honor needs.
Can both sides point to where they think that the court actually has what is before the court for a point-by-point basis? If you think I have it, I'll be glad to look at it again. When I looked at it, and I just realized, I appreciate why you all were going topical, and I appreciate, but the point is, if someone's gonna raise an issue about not addressing objections and not addressing it one by one, then you can appreciate that he is asking for an advisory ruling, because you're not asking on the actual matter before the court. And that would be a motion to compel, what would be a motion to protective order, so.
Your honor, I would point you to the court to,
Hold on a second.
this is the state's motion to compel.
4/22, 2024,
What was the date? I apologize.
4/22, 2024.
No, this is the April 19th, the state's motion, not Meta's motion. I think Meta's motion was April 22nd.
Hold on a second. Okay, thanks, yeah. Sorry, very nicely, thank you for the jump drive. But they all said 4/22 for the dates of filing, and so I was going off that, but the underlying document says 4/19. No worries, we're good.
Sorry.
No worries, underlying document 4/19, 4/54 PM, okay.
Okay, great. I'm sorry.
No worries. Okay, let's
So the platform dispute is started, the discussion starts on page 9.
Okay, hold on a second, so where does it sit?
And at the top of page 11, it identifies all RFPs and interrogatories that have that objection that Meta is
I
asserting.
understand it's supposed to be, right, request, objection, right, and then what needs to be done. And so are we addressing which ones, for your first stage of the argument, are you saying, let's set forth in here, which ones matter by matter that you're saying are waived?
I don't believe we have it in that format. I think that format was attempted starting on page 17, but it just has the request and the response, and does not discuss.
Actually, it doesn't have all the responses, right? Because see, like it's got a summary, right, RFP 20 that says, this request seeks documents related to bulk products, blah, 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 right? 313 as an example, and then created the, and I don't wanna keep going to
Which page are you looking at?
but you said we start looking at page 15.
17. It's the table that runs from 17 to 30. Was the attempt at the request and the responses, just in their entirety. But it does not have the third.
But where does it say what is outstanding for the court and what documents or information that they've provided, so the court would, if you want, we would go back to my pie example, right? What's left of the pie that you're asking for, or what's left of the information? I mean,
Sure, it's just not in that format, and I apologize for that. I was going to point your honor to where we identified the numbers of all the ones that touch on the topics in the body of our brief, but, and that's why if your honor would like, we would be happy to provide it in that format. we will do whatever the court pleases on that. But regarding the platform, the platform-related requests where that dispute is at issue on page 11, when it's 4 and 5.
Sorry, so I look at page 17 and go back to 11 to figure out which one it refers to. Is that I'm trying to understand what you're asking the court to do. Can you walk through the process that you're saying the court should be doing, please?
Yes, what Your Honor just described. The request, whether Your Honor looks at pages 17 to 30 or the actual responses themselves in our appendix of exhibits 1 and 2, either one.
But your appendix of exhibits don't have all the supplements together to know what the supplemental one was, right? So that's why I was asking my question about whether or not there was the waiver in the meet and confers. Remember we were talking about, because the supplemental only addressed some of the ones for 20 to 37, didn't actually address 30, which is one of the ones you brought up in the oral argument.
Well, that was another reason the state originally wanted to do just a short informational supplement with no argument, to have a table to lay this out for the court and to provide some supplemental responses that META has served even since all of the briefing has closed, because I think that's important for the court to have the things involved into, META responding, and that was.
Would it meet both parties' needs if the court gave you X number of days, 7 or less, right? Not required, but if either side wants to provide a non-argumentative table that just gives the history of, look, this is our protective orders on boom, 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 and boom, right? Sorry, let me articulate boom, boom, boom a little bit more clearly. So late in the afternoon. RFP numbers blank, right? Blank and blank. Interrogatories numbers blank, blank, and blank. 30B6 witness topics, well, we know 5 is going to be on there, but other ones, okay? Blank, blank, and blank, okay? This is the response that we received. This was not resolved in meet and confer, or this was resolved with regards to topic blank and blank in meet and confer, and so X is left. And that last one might be subject to a little bit of contention, but the reason why I'm saying that is at this juncture, I have META asserting that these documents, and there, since you don't have your documents specific to each item, some are cross-referenced with different ones with C blank, but you don't say which sub numbers of C blank. For example, I believe it was 12 might have referred people to 2 and 8 in the interrogatories, bless you. I think interrogatory 12, I think you referred to RFP 2 and 8, but you don't say which pages of 2 and 8 apply to interrogatory. So that is why I am seeing, in order for this court to, if I give you a short time frame, offer both parties that option. And if you don't, then I have what you have, and you get the ruling you get based on what you have provided. And if you haven't complied with the rules, you get what you get.
Your Honor, I think we'd like to be more helpful to the court, so I think we would propose.
Besides not comply with the rules.
Yes, the answer is yes, Your Honor.
Yes, Your Honor, we would undertake to do this within 7 days as the court has outlined.
I mean, I can make it shorter. I'm trying to be practical. You have time issues. You've got different briefing issues, okay? You all just had this court, well, I granted you a choice, right? Extra pages. You have certain deadlines.
I was reminded it's Mother's Day on Sunday too, so I don't want to ruin anyone's important holiday. The state is fine with next Friday.
I mean, tell me what makes sense. I mean, from this court's position, I can tell you I want it on Monday. I really didn't think you all wanted it all weekend on Monday. So realistically,
7 days.
7 days would be better, Your Honor. I think we could get a better product.
I was trying to balance people's different time things, that they might have other things on their docket. They may be back here in this department for certain things in between now and then, maybe on other cases. And other departments as well. I'm not the only department here in the 8th Judicial District.
You may be.
Maybe here on Friday afternoon here.
Yeah, right now you might be.
No, I have colleagues throughout the building. No one, this is being recorded. I have wonderful colleagues that work very okay? And I do. I mean that seriously. Okay. But where I was going with that is that I presume you all have other things going on. Some people might need flights to different locations that they may need to be addressing things in different locations. The reason why I was saying a week seemed to be a reasonable time frame that gave you all time to speak among yourselves, and maybe in that intervening time, as you think over on flights back or coordinating with people, maybe you have a different step that might be heading my way, that you want something different, that you might find more to your needs rather than this additional step, which, okay. Now, I will tell you, either side objects to this court allowing you to do this extra chart, is what I'm calling it, okay? Don't take that word in the dictionary.com definition of chart, okay? I'm trying to just put some phrasing on it. But if either side objects, then I'm taking what I've got and I'm rolling with what I've got. I just don't think that you all are asking me to do that. I'm thinking you're trying to make it so that you actually have something that assists each of you for moving forward. But I will tell you, either side objects and say that the court needs to rule today, then I will rule today. Does either side wish me to rule today, or do both sides wish the option to provide something within 7 days?
But, Your Honor, on behalf of META, we do not object to the idea of submitting these supplements. Exactly, I don't know what we would call it, but being a non-argumentative table, as I understand it.
Yes. Okay.
Your Honor, Michael Gayan for the state. State does not object to that as well within 1 week. And the only addition we would permit beyond the non-argumentative table or chart would be to provide the court with the current responses from META to the extent they've been supplemented. I think that would be appropriate as well.
Yes.
Right, and realistic.
And can I ask, Your Honor,
Sure.
as the word chart has been used, but I understood you to suggest something different, to kind of lay out the full request, lay out the objection, lay out the history of the meet and confer in a non-argumentative
I was
fashion.
concerned if I used the word pleading that someone would be telling me I'm allowing oral argument here, or additional written argument, realistically. Okay. It can be done in a chart format. In fact, part of it was on page 17. You all have a partial chart there too. Realistic, folks, the name is not exactly going to matter. What the concept here is to clearly articulate to the court in a non-argumentative or asserting your client's positions. And I do appreciate, as very experienced attorneys, it's going to be a little challenge to kind of just make it nice and neutral. But realistically, what are the RFPs? What are the interrogatories? What are the 30B6 topics that you wish the court to rule on? Okay?
And what are the live disputes?
And what actually, yes, after the live disputes and meet and confer, which is realistically the reason why we normally get that, okay? It's a form, whether you want to call it a form, a chart, a supplement that just advises the court. Now, and I do appreciate that I am hopefully being very clear. It's not to say, and we believe that this is our response because of X, right? Or Y supports our response. And I'm not saying that either side can supplement their underlying, to the extent, if there were supplemental responses, yes, I need to know about that and what that supplemental response is so I have the most up-to-date information. However, if somebody in reviewing this says, guess what, oops, we probably should have added 5 more things and added 15 pages of additional explanation to explain our objections or our response,
It's not allowed.
Not allowed,
Gotcha.
because that would be a substantive supplement. This really is to get you all to kind of focus on what you want the court to rule on, and that since you are not requesting, not agreeing to a topical format and want to have it in the objection by, RFP by RFP, ROG by ROG, but I at least need to see what you're asking me to rule on. So that,
And Your Honor, do you want us to provide some summary of the meet and confer process, or is that not necessary?
I think the simple answer is, in your motion for protective order, the outstanding issue left here is blank, not a argumentative position, but it's very clear. We met and conferred on the 30B6. We resolved topics blank, blank, and blank. The court only needs to resolve topic blank, whatever's left, right? I mean, it's a statement. We met and conferred on the RFPs and the interrogatories. The court only needs to address interrogatories number blank, blank, blank as set forth below.
Or maybe or maybe a topical limitation, for example, if the state's request was 2015 and now we've agreed to 2017, just list that so the court can follow from
Bingo.
the request to the response to the
Yes.
agreements on meet and confer that may have narrowed the dispute and what's the live dispute to the court.
Give it your date one. If Met is at 2019 and the state's at 2017, then Your Honor, the outstanding issue after our meet and confers is whether the time period for interrogatory blank, blank, and blank, or production of documents blank, blank, and blank is whether it should go back to 2017 or 2019. With regards to, and that's kind of like one of the easier ones because it's got a specific time component, yes. With regards to production of, request for production of document blank, we received these pages, okay, that relate to the first thing, but we don't have anything, maybe the under 13s, okay? So it's telling the court what the court actually needs to rule on. And I mean, I've got all the topics. I mean, literally, I could rule if you all wanted me to do the alternative format based on what you said, but then you've got your other issues, and if you aren't waiving those other issues, then I'm not gonna do it. There'd be no reason for this court to do what would be an advisory ruling that would not have any reason or support from case law, since you all don't want me to. Go ahead.
Your Honor, do you see any issue if the state's chart or table or whatever followed Meta's convention on page 19 of their motion?
Hold on a second, let me get back to their motion for protection order, page 19, 1 second, please. Yes, see.
Where, and specifically the basis for the objections, where they have abbreviations describing, I could envision a column where we identify the topics that are in dispute for each request and just have it abbreviated so the table is not, 50 pages long. Maybe it could be something a little.
Right, but the challenge with this is it didn't tell me what was actually left.
Right,
Sure.
that's
Sure.
right, I understood the court.
Yeah, I mean,
Right,
like
and
I
I
said, I've
have-
got some pretty charts, okay, thank you, I've got some very pretty charts, they're very nice. The thing is, it doesn't tell me what do you need Department 31 to rule on May 10th that is actually left and outstanding on either a straight discovery basis,
Sure.
which seems to be back where you want this court to go to, or some joint stipulation on the record, and maybe sure some .50 that you want something different and that there's lawyer of any claims of not having it.
Understood, Your Honor, and I only meant this format for what's left because we have these topics as we've argued, and I thought that might be a more efficient way to let the court know this is what's at issue left, and we could describe it in that.
One challenge with the way this is, just to let you know, and I would have dealt with it if you wanted your modified form, is while it says some of these bases for objections, since I also have an objection to that these aren't objections that are consistent with Nevada law, right, that there is not the explanation, then there needs to be a little bit more.
You need to see the actual objection.
I need to see
Not
the
a
actual,
coded chart.
unless the state is waiving the concept that the objections aren't truly objections and is not asking, if the state's not asking the court to just rule on the underlying what should and should not be provided, but is also wanting the court to say whether or not the objections are appropriate objections or if they somehow impact the court's ruling, that's going to make a difference. And what I understood is the state's not waiving that, is that correct?
That's correct, Your Honor.
So that's why I would need to see the actual full objection to address Venetians and other cases, right, and to deal with that. So,
That's very helpful, Your Honor. I know
and
it's
if you all
late in
want to
the
do
day.
it jointly, you know what I mean, and do it as one document so that you're not each putting it together. I'm not going to care if it comes as 2 documents or 1 document. What I'm going to do is I'm going to look to see what it allows this court to do. Is there any reason people need additional oral argument? Does everyone think that they've had an opportunity to give their full oral argument and you just basically really need the court to do an order? And if you're just saying the latter, let me tell you something else. I'm going to tell you that it might be helpful to this court if you submit a proposed order, the court grants or denies, RFP, blah, blah, blah. Because if not, the challenge is this is gonna end up being a long minute order, right? Because if you're not requesting to come back, I can't do it from the bench, so it means I'll need to do it, type it out in writing. I'm trying to balance the time, I'm in back-to-back trials, surprise.
Here's an inquiry.
Sure.
Would it be possible to just put it back on calendar for your ruling without argument? I guess I'm just thinking.
Some federal judges or magistrate judges have done that. They just call us in, set a hearing, and then just tell us what the ruling is, and we go.
And then that would be easier on the court in terms of a proposed order, well, either on us, I guess, going through like proposed orders.
Well, but you still have to get an order. But the challenge, I start another trial, unless it settles on the 20th. The challenge with that is, remember, if I'm giving you all the week, that gives you to the 17th, which then I have to look at some things, right? I'm in trial.
Okay.
It presents that,
Yeah.
what's your timing on when you want to try and take the demo, et cetera? See there.
Well, and the state, after, I know we discussed things in March, but the state is amenable to doing this process properly and getting what we need. And so we did discuss in the hallway with counsel, depending on the court's ruling, they may need some time to gather and produce information, and the deposition won't happen until that's done. So we understand the court is busy. The state is not asking the court to rearrange its schedule just to accommodate this case, which is just one of many, many cases.
I'm more than glad to try and do it if I've got time to actually do it. The challenge is the trial concept, as you can appreciate. Each and every one of you, when you're in trial, you wouldn't like if I all of a sudden popped another, you know what I mean? You pop the ones you really have to, but.
Well, Your Honor, we're happy to do the chart by next Friday and then a proposed order.
Or the court
the
might,
following
the
week.
court might, and then give you a heads up, the court might, because you have flight people. I have to look to see how in-depth it is and how much there's there, but I might. It's a Tuesday.
Yeah, maybe we could do
May 30th or 31st, maybe, because
for a hearing.
I'm in a 2-week trial that starts the 20th,
But, Your Honor, would it meet the court's needs if we submitted proposed orders a week after we submit these charts?
And no hearing, I guess, we would just simply submit the proposed order.
Yeah, and I was just going to propose the same thing.
Yeah, that's fine. That's what I was trying to go for, you know what I mean? But what my one challenge is as very experienced counsel, I'm likely to get two very different charts of what the world is for this court to rule on, right? Like maybe 20 through 36, is it still quote outstanding? Or maybe it isn't still outstanding. Are they going to tell me every single one on the 30B6 pretty much is there because of an issue about whether or not it goes to Meta Platforms, the defendant, versus going to Messenger? Do you see? I'm internally trying to figure out what might make the most sense here.
Your Honor, we're happy, the state's happy to do whatever works best for the court. The only thing I'll note is I just remembered I have an evidentiary hearing in Reno on May 31st, and I have to be there on the 30th. Not that I have to be here for the next hearing. I'm sure one of these many competent lawyers.
The 20, I'm in trial, I just don't know. I know I have witnesses. That particular trial involves some people who have very tight deadlines and other commitments due to the nature of their business. And so it's not a case where there's a lot of flexibility with just some local people, and it's a jury trial, it's not a bench trial, so I don't have as much flexibility. But I might be able to do the 29th. If I had you come in at 8:30 on the 29th, is everybody here, or can we, or you can appear remotely, you know what I mean, since you're pretty much just listening and asking questions. Would the 29th work for people?
That works for the state, Your Honor.
So here's what I'm gonna do, we're gonna blend things. You all have till the 17th to get the court a chart, the form, the outline of what's pending directly before the court by I'm gonna say by the 23rd, by 23rd at 4:30. You're gonna submit your proposed orders, and then the court's gonna hold a hearing on the 29th. Everyone can appear remotely if they want to. Or you're also welcome to come in for it, it's up to you. And the intention of that 29th is that whatever's not resolved or the court may be ruling on, I'll either A, rule from the bench directly, taking into account the proposed orders. If I had given you back the proposed orders before then, but it's not likely because I'm in the middle of trial. And that, some of you know other large cases that you have different issues with things that need decisions and other things. So that being said, yes, including involving your client, including involving, you have other clients that are very, so I'm just saying there's one of me.
I sympathize.
You myself and I, so I'm just trying to do, so if I do the 29th, the intention, but I might have a couple of questions is the reason why. So I'll give you that heads up for whoever you may want to staff it with, is what I'm saying, is I might have a couple of questions. But I'm not intending to do additional oral argument, but I might have some questions for people to answer. And then the court would be able to make its ruling hopefully on the 29th. Is that
Your
work for
Honor,
everyone?
Yes, that works. I just missed the time on May 23rd.
8:30.
No, May 23rd. The
Oh, May
proposed order.
23rd? What did I say, 4:30? I think I said 4:30.
Yes.
I appreciate you all, but please, the 11 o'clock filings.
I was just gonna say, just for clarification too, the filing that we would do next week, that would be a filing. The proposed order, do you want that filed and submitted or to your inbox?
I'm
or
going
how
to
do you-
leave that to you all's choice, how you wish to do it, okay? Because normally if it was a proposed order, it would not be filed. It would go to the order in the court app as a proposed order. If anyone feels that you need to submit it, tell me now and we'll just get it consistent on both sides.
Yeah, I was planning on filing it, but I had certainly thought that sometimes it's easier to have that submitted, so if you want a Word document, or we can email it, I don't know.
The challenge if you file it is what do you call it? It's not a order of the court, right?
It would be
Normally when you submit competing, let's put it this way, if you're submitting competing orders after the court has done its oral pronouncement from the bench, Division of Family Services, and Rust versus Clark County, right? Those don't get filed because they are proposed orders that are incorporated in the court's ruling. Here, the documents you are providing, I will have not made a ruling, so realistically, they're not anything official, which is why normally they would come to the order in the court app, because the court may choose not to adopt either the proposed orders, right? Because I won't have made a ruling on it, right? It's more like a proposed.
Well, I was just looking at the document codes, Your Honor, but how about this suggestion? We'll just title it a status report, but it would be status proposed order, and we would file it.
If they're requesting it for whatever reason, so you okay with that?
I mean,
But see, the one challenge is that you're asking to file something on something that really hasn't occurred.
well, Your Honor, Michael Gayan for the state. I mean, Mr. Polzenberg's whispering, he's probably wanting it in the record. I understand that interest. Another thought for the court's purposes, so you can do what you need to do, would be for the parties to email it to the court in Word and copy the other side by the deadline. And if a party wants to file their proposed one attached to a notice or something, so it's in the record, they can do that, but it really would have no function other than to say,
Because
see,
you
look here.
understand you're submitting something on something I haven't yet ruled on. So it'd be very interesting to try and say what purpose that has, right? It really is kind of like a 7.67 bench brief. It's more like what it is, right? Because it's a concept of really providing the court the information just to help expedite the process of getting the drafting done and for point of reference, realistically. I mean, seriously, you can submit your charts in Word and it really will give you the same effect, won't it?
We're filing our charts, right?
Right, but what I was saying is if you provided the court an extra copy of your charts in Word format to my JEACC to the other side, it has the same impact as if you were to file a proposed order, because all you're doing is providing the foundation of what's before the court. You're not providing any ruling of the court, right? The magic words grant, deny, or anything else I may choose to add to it, grant in part, deny in part, and for any reasons, it's going to come from the court. Honestly, I don't have a preference as long as it's clear that nobody is submitting, quote, a proposed order on something that this court has already ruled on, because that would not be accurate.
Well, we know you haven't ruled on it. It would be our proposed order that we would be submitting in advance of your ruling. That's what it would be.
If both sides wish to do that, then we'll come to the agreed upon way. It's
Your Honor,
going to be
not
fine
gonna-
with as long as it's accurate.
Yeah, Your Honor, the state's not gonna object if they wanna do that. I suppose that's kind of a local rule in federal court here anyways. You submit the order, you hope that the court's going to sign even before there's a ruling, so whatever. If they want it in the record and they wanna attach it to a notice or something, but I don't think the court needs to do anything with that document. It's the Word version submission, I think that the court would take and maybe take some of this, take some of that, and make an
I'm
order.
going to care about the courtesy copy that you're going to provide me in Word in addition to what else you're going to provide, right? Because that's for the court's purposes. Okay, other than this has been wonderful. You all promised that you'd be out of here 15 minutes ago. My team, thank you again, and thank you for Marshall, who came in on a Friday afternoon to assist us, and now here way past the normal time, so thank you as well. Okay, have a great one, everyone. Have a great weekend. You guys
Thank you, Your Honor.
Happy Mother's Day.